Good day. Thank you so much for tuning into our webinar today. Today we will be discussing contested divorces, which means not settled and defended divorces. I am Izon Oosthuizen from Boertekoper Attorneys and I will be your presenter today. So for a quick recap of our last training with regards to divorces, we discussed an uncontested divorce, which is normally accompanied by a settlement agreement where the parties have had a round table or an amicable discussion and decided upon the division of the estate, as well as if there are minor children, how the minor children's parenting plan will be set up. An uncontested divorce, like I said, is normally combined with a settlement agreement, and in a contested divorce, these issues have not been dealt with in a settlement agreement, and therefore the court needs to deal with all of these issues and the division. So where does the difference come in? Like in an uncontested divorce, a summons will still have to be issued by the court. It will be accompanied by particulars of claim, but if it's an uncontested divorce, it will also be accompanied by the settlement agreement. This process, however, changes when the defendant, who is the spouse who's being sued for divorce, does not necessarily agree with the plaintiff's claim, and they then defend this action within 10 days of being served with a summons. They will then be entitled to, within 20 days, deliver his or her plea and counterclaim. So in your particulars of claim, this is your proposition of how the division should be done. The particulars of claim will then be pleaded to and/or a counterclaim will be issued by the defendant, where he or she will then give their counteroffer as to how they feel this divorce should be dissolved, or the marriage in essence should be dissolved. So this will then implement the necessary steps which have to be dealt with by the court in respect of which items needs to be decided upon. The document which they will reply to will address each and every allegation that was made in the particulars of claim, as well as their counter to each of those aspects. A counterclaim is a defendant's proposal upon how the marriage should be dissolved. The plaintiff will then also have the option to reply or replicate to that counterclaim within 10 days. Once this is done, after the final pleading, pleadings are said to be closed. It's important to note that an amendment to a pleading, which means a proposal for instance, can always be brought up and until the point of the court handing down its final judgment. Since we're dealing with contested divorces, the disputes might be with regards to the children, the access, the parenting plans, the maintenance. It could be a very large estate where assets have been dissipated, for instance, where there are international accounts, where money has been moved around quite a lot, and therefore forensic accountants or liquidators are required. The family advocate can also obviously be involved and will be involved in all cases where there are minor children born out of a marriage. Upon divorce, the family advocate will then deliver their report. However, should this report be contested by, for instance, the defendant or the plaintiff, and that party feels that the report recommended is not in the best interest of the minor children, or that situations have dramatically changed in the interim, that report can be challenged and therefore further investigations will have to be ordered by the court. If you are a frequent listener to our webinars, you will be well acquainted with the term family advocate. This is an impartial third party who is appointed by the court to always look at the best interest of the minor children. Divorce is a very emotional and difficult roller coaster that not only the parents go through, but also the children. They work together with social workers, psychologists, psychiatrists, etc., to ascertain what the surrounding circumstances are, and they will then make recommendations to the courts on how they feel that the points of access should be dealt with. They will also look at parental alienation, should that be applicable, and make their necessary recommendations to the courts in this regard. They will always try and make sure that the parent-child relationship is upheld, and should that relationship have suffered any damage, that the necessary plans are implemented to make sure that that relationship is restored and that it builds on for a future relationship between the parent and the child. They will look at the current relationship between the parent and child as well as the future relationship between the parent and child. And therefore, the family advocate's report sometimes does get disputed by the other spouse, because it could be that the situation or the circumstances have dramatically changed. We look at an instance where one parent was, for instance, a substance abuser. In that instance, should that parent show that they did the necessary work, they went to rehabilitation, they are actively trying to better themselves and better their lives, to build a relationship with their children, the court will take that into consideration. The family advocate will take that into consideration. And depending on, irrespective of whether the parent has a pre-existing or any other condition that might impact the child, the family advocate will then implement a phased-in approach or an age-appropriate approach with regards to the children, to make sure that their routine and their lifestyle is not unnecessarily disrupted, but that we are still acting within the best interest of their child to make sure that they have a relationship with both parents. When the family advocate's report gets challenged, for instance, the court will look at each parent's impact of their actions on the minor child. They will look at the current circumstances as well as the work done by that parent to either better or worsen those circumstances. This report can only be challenged if there are valid reasons as to why it should not be adopted by the court. It's not as easy as it seems, and you really will need good foundations and serious bias to have this overturned. Should a parent's situation, however, drastically change, either positively or negatively, the court will definitely take that into consideration when reviewing this report. A new investigation may then be conducted based on new evidence, and the final report will then be sent to court, whereafter the magistrate or the judge will make their final decision in this regard. The formal process will then continue. Once the pleadings have closed, the parties will deliver their discovery documents. Discovery documents are documents that is used to prove your case, which means if you are of the opinion that assets are being dissipated, for instance, or that funds are being redistributed, so that one spouse does not have any access to it, etc. This is where you prove it. This is where you will make your case to the magistrate or the judge. Documentary evidence will be delivered to support your oral evidence that you will give at the trial stages. Each party has the right to view the other party's discovered documents to make sure that they can duly prepare for the trial. The court will then have to determine how long this trial is going to take, which means your law and order moment. A pre-trial will be held to narrow down the issues that are in dispute and also identify the issues which are common cause. So these issues are identified out of the pleadings and how you have answered to each and every allegation, like we discussed previously. And that is also why it is important to note that pleadings can always be amended up and until judgment is handed down. In the pre-trial conference, the court will also attempt to limit all of the issues that are on hand, try and see if it can't be dealt with previously before they allocate a trial date, and they will also then decide on the length of the trial. This will vary with regards to how many expert witnesses you, for instance, need to call, and also the amount of documentary evidence and investigation which needs to be dealt with by the court. So once a pre-trial conference has been held, the plaintiff or the defendant will apply for a court date. The registrar of the court will then allocate this date and the matter will be set down for hearing. The trial proceedings, which is your law and order moment, dung dung, will then take place, and each party and or their legal representative will be given an opportunity to present their client's case, and they will use the necessary evidence in support thereof. It's important to note that there are specific rules to comply with when giving evidence, like for instance, discovery. And that's why it's always advisable to ensure that you have the correct legal team on your side to make sure that your rights are duly secured. So once the trial has commenced, the court will take into consideration all submissions made to it. So this can be in terms of discovery, like I said, your documentary proof, as well as oral evidence which would be laid. So this can be either one of the parties, it could be character references, it could be psychiatrists, it could be the family advocate being subpoenaed to give evidence. It can be liquidators or accountants. The court will then raise certain aspects should it require clarification, and they will indicate whether further investigation or further expert evidence is necessary. The trial can then be postponed if need be, to enable the parties to respond to the court's request or to present any further evidence with regards to certain aspects in contention. There is always a risk that the court will not be able to decide on a specific aspect as it requires in-depth expertise. So yes, they will be able to take consideration of the reports of experts that are submitted, but the court does not necessarily have the time and the resources to do the investigations themselves. They will then make a ruling on the division of the estate, the access and care for the minor children, as well as the aspects of certain matrimonial assets and liabilities, for instance. So then in essence, the marriage will resolve, but the division of the estate, like I said previously, will be referred to an expert to investigate and make recommendations on those aspects in dispute, which the court will then take into consideration and make a ruling upon at a later stage. When we look at the duties of a liquidator, the court has the power to appoint curators. They may nominate or empower somebody to be a liquidator, a receiver, or a curator. Those people will then collect, realize, or divide a specific estate. In normal business partnerships, for instance, a partner will only get the equal shares of what their contributions were. But this is not necessarily the stance when we look at divorces and how property and estates accrue, whether we're looking at in-community of property or the accrual system. Again here, it's important to take into consideration your marital regime. Let's look at a practical scenario. In the matter of Engelbrecht versus Engelbrecht, the court held that joint ownership of another's property is a right which a spouse acquired during the conclusion of a marriage in community of property. So unless they make precisely the same contribution to that estate, it could be that the party who contributed less to the marriage can, upon dissolution of the marriage, also benefit to the same extent as the party who, for instance, contributed more. This will be a scenario where one of the spouses have left their jobs to, for instance, take care of the children, and then 10 years later only entered into the employment market again. That person did not necessarily contribute to the marital estate in a monetary value. However, in terms of emotional support, raising the children, etc., their contribution was immeasurable, and therefore they cannot now be prejudiced, and the court will divide the estate on an equal basis. So what is the role of a liquidator? Firstly, it's important to note that the court will not always appoint a liquidator, and it's also not obliged to do so. A liquidator, a forensic accountant, a curator are people that are only appointed at the court's discretion. The size of the joint estate will be taken into consideration, as well as the amount of in-depth investigation that is required. It's always encouraged that parties attempt to settle a matter amicably, but in some instances, the only remedy would be for a liquidator or forensic accountant to be appointed to make sure that it is an equal division of the estate. But we have to remember that these people are also rendering services, and therefore they will also be entitled to their fee. So what will they do? They will request both spouses to provide true and proper accounts of all their assets. They will then evaluate all of the assets of the spouses, which includes the movables, which means your local furniture, etc., as well as the immovables. But this is always subject to legal exclusions. They will then establish the legitimate liabilities of the estate of both the spouses as well as the joint estates. They may interrogate and do the necessary investigations of both spouses should it be necessary, and they will have access to any premises for the purpose of evaluating those assets. When we look at Section 9 of the Divorce Act, it deals specifically with forfeiture of patrimonial benefits. So this means once a divorce order is granted on the grounds of irretrievable breakdown of a marriage, the court can make an order that the patrimonial benefits of the marriage be forfeited by one party in favor of the other. This could be either wholly or partially, and this is only when there is circumstances present which gives rise to the breakdown of the marriage and any substantial misconduct on the part of either of the parties. But remember, we have a no-fault system. The court therefore needs to be satisfied that if the order for forfeiture is not made, that the other party will, in relation to the other spouse, not be unduly benefited. They will take into consideration, for instance, the duration of the marriage, what gave rise to the breakdown of the marriage, as well as the contributions of each party in respect of the assets and the estate as a whole. If I could make the CSI sound, I would do it here. So forensic accountants will, in this essence, be looking in depth into the law. They will assist an attorney as well as the court to compile specific reports and lead expert evidence at a trial. They will be called as witnesses in the trial, and they will therefore be subject to cross-examination as well as re-examination. They will also attend to valuations, they will look at damages, they will quantify certain aspects, and they will do fraud investigation should they deem it necessary. They will then assist in unfolding any dissipation of assets or fraudulent transactions by a spouse in the divorce proceedings or throughout the marriage. Remember, they don't need to just look at the accounts and at the evidence from the date of divorce or inception of the divorce, but they look at it from date of inception of the marriage. They focus specifically on any concealed assets or sources of income. They determine maintenance dependency of a spouse as well as children, and they also attend to evaluations of any business holdings of either of the parties. So once all of this has been said and done, the aftermath remains. This is where the liquidator, the forensic accountant, and/or the curator will submit their final reports to the court for their consideration. The court will then make a final order upon how the estate, the assets, the liabilities, and other patrimonial items should be dissolved. It's important to make sure that there is a specified method as to how the transfer costs and the transfer methods should be effected. This will be the case in change of ownership of vehicles, for instance, transfer of half shares or whole shares of properties. This will ensure that the other spouse cooperates in these processes of transferring and dividing those specific aspects. This will save you a lot in future legal costs should that spouse not be willing to cooperate. Then, if the court has ordered the cooperation or the method or the time limit, then you can hold them in contempt and the court can deal with the necessary and apply the relevant remedies. Contested divorces, as you can see, is a very lengthy and invasive process. There are various experts involved, and therefore it can also become very expensive because each of them are entitled to their fees for the services rendered. It's important to remember that a party may at any stage prior to judgment being handed down enter into a settlement agreement to limit these lengthy periods as well as the hefty costs which come with same. Sometimes settlement, however, is just not possible, and therefore it's important to have the right people and the right team in your corner to assist you with this process. Wetakopo, if you did not know by now, is the answer to my previous question. We are the right team. We have the necessary expertise and the knowledge and the know-how to make sure that your interests are protected each step of the way. Thank you for your time today. I really appreciate it. And should you require any assistance with regards to divorce, mediation, or any other legal matter, feel free to contact our offices or send me an email or pop in for the best coffee in town. We would love to have you, and thank you again for your time today.